On this video, I'm going to share with you a recent claim I worked where we successfully proved to a judge my client was injured at work and was awarded medical treatment the insurance company failed to provide. I'm Craig Armstrong, and since 1983, I've been helping individuals who are injured at work in Oklahoma get the proper compensation they're entitled to receive. If you've been injured at work and have a workers' compensation claim or a Social Security claim and are being pushed around, visit my website and set a time to meet with our firm. Also, if you need more information about workers' compensation, check out the rest of my videos on my site and channel. Here's what happened. My client was working with their supervisor setting up a folding table when the table legs gave out and the table dropped, pulling my client forward and down to the floor. Because of this incident, my client sustained injuries to multiple body parts. The insurance company initially admitted the incident and provided approximately 2 months of medical treatment and payment of temporary compensation. The insurance company subsequently determined my client never reported any injuries to a supervisor on the day of this incident and that her injuries were pre-existing. After being denied medical treatment and compensation, my client retained my office. My client's claim was tried to a judge. At trial, my client's supervisor testified for the insurance company. The judge ruled that my client's supervisor provided substantially similar testimony to my client. The judge found my client's testimony to be credible and found her claim compensable. She was awarded retroactive payment of temporary total disability from the date last paid and continuing temporary disability. The insurance company was also directed to designate a treating physician and authorize medical treatment to all injured body parts. So here's what went wrong. My client's claim was denied by the insurance company only because the insurance company didn't do the due diligence they should have. You see, the insurance company is the employer's insurance company, and they have an opposite interest than the injured party. Relying on the insurance company to work in your best interest is like hiring a bank robber to be a bank guard. If the insurance company had done their due diligence and interviewed my client's supervisor, they would have realized my client's injuries were in the course and scope of her employment, and they would not have terminated her benefits. Unfortunately, there's more to the story. After the workers' compensation judge found my client's injury compensable and awarded almost 5 months of back benefits and directed the insurance company to designate treating physicians, the insurance company appealed the decision. The appeal prevented my client from receiving the pay she was awarded or access to medical treatment she was awarded. Due to no fault of my client, the court reporter that transcribed the trial proceedings neglected to timely forward the transcript of the trial proceedings to the appellate panel. Responsibility to ensure the transcript is submitted to the appellate panel falls on the insurance company, which they did not do. Through my efforts, the trial transcript was obtained. The appeal was heard in front of the appellate panel. The trial judge's decision was unanimously affirmed by the appellate panel. Following entering of the decision affirming the trial judge's award, the insurance company paid my client almost 18 months of back benefits. Unfortunately, there's more to the story. The insurance company neglected to designate the treating physicians authorized to provide medical treatment that they were directed to do so in the court order. So what did the insurance company do next? The insurance company filed a motion to dismiss my client's claim for failure to pursue medical treatment within the statutory allotted time frame. The reason my client was not pursuing medical treatment was because the insurance company did not designate the treating physicians and authorize treatment as they ordered to do so. After filing an objection to the insurance company's motion to dismiss, the insurance company's attorney delayed the proceedings and my client's ability to gain access to medical treatment by requesting a new judge. The case was tried approximately a year after the appellate panel affirmed the first judge's order directing the insurance company to designate a treating physician. Here's what happened. The insurance company argued to the new judge the physician the claimant had been treating with before the claim was denied became the designated treating physician once the claim was found compensable. Trial judge dismissed that argument, noting the insurance company was directed to select a treating physician by an earlier order, which the insurance company admitted in open court that had not done so. The insurance company's behavior of not looking after my client's interests was further demonstrated at this trial when the insurance company admitted to the judge they had received a request for reimbursement from my client for medical expenses incurred during the period treatment was denied, and still had not issued any payment to my client. The real kicker to this entire fiasco is that the premise of the insurance company's motion to dismiss was an Oklahoma statute that, when correctly read, implies that after timely filing a claim and requesting benefits within 6 months of filing, the claim shall not be dismissed. My client complied with that statute, but the insurance company fought to deny benefits on what was found to be a frivolous argument and not supported by law. The insurance company, on the last day to appeal the second judge's decision, designated a physician. However, the battle continues. The first judge's order found multiple injured body parts and directed the insurance company to select multiple treating physicians, one for each body part injured, which the insurance company did not do. What will happen next? I'll be going back to court and arguing the insurance company is non-compliant with a final order and has failed to designate a physician for all body parts. This scenario is a classic example of the insurance company not following the law. Without representation, my client would have never been able to navigate herself through 2 trials and an appeal to obtain medical treatment and compensation for lost wages. Insurance companies work for the employer and clearly do not have the injured worker's best interest in mind. If you need more information about your workplace injury or Social Security claim, check out the rest of my videos on my channel and website. We make videos like this educating workers of all their rights when it comes to workplace injuries or Social Security claims. If you've been injured at work, schedule a call with us today and let us help you create a plan to get you the compensation you're really entitled to. I'm Craig Armstrong. I look forward to helping you.